Hello and welcome to Liberty Law Talk. I'm your host, Richard Reinsch. Liberty Law Talk is featured at the online journal Law and Liberty, which is available at lawliberty.org. I'm Richard Reinsch. Today we're talking with Philip Hamburger about his new book, Purchasing Submission, Conditions, Power, and Freedom. We're glad to welcome Philip Hamburger back to Liberty Law Talk. We featured his work extensively here, including his wonderful book, is Administrative Law Unlawful. He's also the author of earlier studies, Law and Judicial Duty, and Separation of Church and State. He's the Maurice and Hilda Friedman Professor of Law at Columbia Law School, and he's the founder and president of the New Civil Liberties Alliance, which maybe Philip can tell us some about what they're doing and what their goals are. But Philip, welcome back, and glad to have you to discuss what I'm sure will be another groundbreaking book. You writing, of course, as one of our great legal historians, but someone who is also able to write about contemporary developments in governance that should trouble us.
Well, thank you. It's great to be here with you. I love these podcasts and everything Law and Liberty does, so it's an honor to be here.
Well, thank you.
Really appreciate it.
So tell us about this book, Purchasing Submission. Who is purchasing submission?
Right. The government. It's right, of course.
Aren't they always? Yeah.
They collect our money and use our own money in a sense to suborn us and to purchase our freedom. And they do it in more interesting ways than I think is commonly recognized. So when the government gives one money or gives one some other privilege like a license, they often attach a condition to it. You can get a license as long as you let us use a piece of your land, or you can be a lawyer subject to the following conditions, or we're going to give you research grants, but you have to do the following. And these conditions are widely recognized by scholars of constitutional law as a sort of technical legal question. A technical question as to when conditions violate constitutional rights, because ordinarily a right is violated when some sort of coercion is applied, some sort of force of law is thought. And so when you're simply asked, well, have you done X, Y, and Z? And if so, we'll give you money. It doesn't seem terribly pressured or coercive. And as a result, it seems a technical problem. When do these conditions actually violate one's rights and when do they not? And there's whole literature on this. But it's not just that literature, I think, is incomplete. I think this fails to recognize what's actually going on. There's a much bigger problem. It's not just a threat to rights. There's a purchase of consent to a whole new mode of governance, an alternative mode of control. And so when you step back and see that, conditions are no longer a technical problem. It's actually a profound question of political theory and law.
Thinking about these conditions, which you kind of go through a range of different types of conditions that seem to be attached to privileges the government is offering you. Do you see yourself as is this sort of groundbreaking in the sense of people have noticed this, talked about it? There's been some judicial notice of it, although I take it from the book, not enough. And you see yourself with this book trying to call our attention to this way the government is increasingly operating by sort of stripping us of rights and offering for porridge, and we give that because we want that.
Right. So I hesitate to say anything I do is groundbreaking, but I do think it is new to see the breadth of the problem. And there are two layers to the difficulty. One, as we discussed, is the threat to rights. They give you money in exchange for giving up some of your speech, for example, which is very common, I'm afraid. But it's a much broader problem in the sense that it's a new mode of governance. One's giving up not just their rights, but one's freedom of self-government. If you think of one way of thinking about it, is it's a new mode of irregular pathway of power. So we're all familiar with the regular avenue of power through acts of Congress and the courts. And you can get that from Schoolhouse Rock, or you can get that from the Federalist Papers and the Constitution. Then there's an alternative pathway of power, an irregular path, which is through administrative rules and adjudications, where you're commanded, do this, don't do that, and if you violate that, we're going to bring you in front of an administrative law judge to punish you, make you pay a fine. And that imitates the regular avenue of power in creating binding rules and binding adjudications, but not in our institutions, those of the Constitution, but in new institutions that have unelected lawmakers, the bureaucrats, and judges who aren't really independent. And that dichotomy between the regular and the irregular path between acts of Congress and administrative rules is quite familiar. But it turns out there's another irregular path. There are a host of these, but the main one that's been missed is this purchase of submission, because sometimes the government, when it cannot get something through Congress, or doesn't think it will, and it cannot get an administrative rule because it might be unconstitutional or politically unpalatable, it then will turn to another irregular path, not an agency rule that purports to bind, but rather a condition on the receipt of money. And what's interesting about these conditions is they do not purport to bind. In fact, the whole point is they're not binding. They don't really restrict one, so the theory goes, because they're just conditions on money. And that liberates the government to do all sorts of things it never otherwise could have done, things that would have been impossible even through administrative power. So it's an additional irregular path, and therefore profoundly dangerous, because if you think of all of this as evasion, there's a cascade of evasions. You first evade the Constitution through administrative power, and then you evade it yet again through purchasing submission. And so it's moving ever further away from law.
Listening to you, as I was reading this book, I thought I was reading this book with your other book is Administrative Law Unlawful in mind, and you've been talking about this, that there you argued you weren't so much concerned with constitutional law regarding the administrative state. What you wanted to show was how the administrative state operates outside the bounds of constitutional norms, basic structural powers, and responsibilities and accountability. And as I read this book, I thought, well, he's done something like that here too. Although
I beg to differ.
Yeah, sure.
So I actually, in the administrative law book, I actually was making a constitutional argument, but it wasn't the conventional one from recent cases and doctrines, but rather by showing that there was a danger out there of this irregular power, which was familiar to the framers of the Constitution. And so we shouldn't assume that administrative law is something new and unattended to by the Constitution.
Okay.
Here, there is some parallel. You're absolutely right, that this is similarly a study of an irregular path of power. But this one's actually much worse.
Yeah.
If you thought administrative law was bad, worry about conditions. And if you think administrative power is actually okay, just needs a little trimming at the edges, you shouldn't be complacent about the next irregular pathway, conditions, because this subverts our rights and undermines our self-governance in a way that administrative power does not. At least administrative rule is published.
Yeah.
We all know what it is, and it goes through a process. Conditions don't have to do that, and many of them are private.
Help help listeners understand maybe more concretely what you're describing here. Like, what are prominent instances of conditions that the government uses?
Well, Joe Biden, our president, has helped people understand this. And so in that sense, the book is unexpectedly relevant. When the administration tells states, we're going to give you money for Medicaid and Medicare, but only if you make certain requirements regarding vaccines, what they're doing is regulating the states and the people within the states through purchase of compliance. When the government gives money to, let's say, Columbia University for research and says, here's money for research. Oh, by the way, though, you have to first assure us that you have institutional review boards, which will censor what one can read and what one can say and what one can publish. What it's doing is it's paying these institutions to regulate people like me. It's a regulatory condition, and it's doubly bad because it works through a private institution. So what we have are a lot of not just unconstitutional conditions that violate rights, but conditions that are regulatory, that are substitutes for the command of a statute or the command of an administrative rule.
As I was reading your book, one thing that comes to mind is sort of a prior choice decision that's been made, that the spending power, that there is sort of a standalone spending power the federal government possesses,
right,
and can do whatever it wants, like build a sidewalk for fitness reasons in towns across America, fund that. or be heavily involved in education or things like that, where you say, well, where does the federal government have this power? Well, as I was taught in law school, it's the spending power.
Right.
And how do you think about that problem?
Well, it's funny. I was also taught that, but the difficulty is to find that spending power. I thumbed through the Constitution. Where is it? Is it on page 1, page 2? You read through it ain't there. It was found there. So the Article 1, Section 8 gives a power to lay and collect taxes, duties, and so forth. And there's a limit on that power to collect taxes, and that limit is you can collect these taxes to pay the debts and provide for the common defense and general welfare of the United States. What we've done is we've replaced the comma after excises and inserted a semicolon. And in fact, Gouverneur Morris, in drafting the Constitution, tried to do this. And then the convention said, no. This is one clause. You're not splitting into two. But by interpretation, we've created a general spending power. So where spending had to go through individual enumerated powers, and thus was limited in its subject matter, it now just can be done and is not limited. And so conditions on spending are unlimited, which means you can regulate through conditions in ways that you could not regulate even with the expansive reading of congressional powers. It gets worse than this, of course, because the so-called spending power, or the limit on the taxing power, has to be for the common defense and general wealth of the United States, which, if it means anything, is it doesn't go to or for the states. So, in fact, all the spending in aid to the states is unconstitutional, but the courts have just ignored this. And with that spending to and for the states, a lot can be extorted from them.
And then you couple that with, as I was thinking about it, the ability of the federal government to borrow unlimited amounts of money.
Yeah.
And also having, vast revenue as well coming in. It's a unlimited source of power. And there's also this aspect, John DiIulio has written about this acronym called BigPAP. And the idea being that the federal government is able to use states, nonprofits, all sorts of other agencies to, in effect, regulate the country without actually doing it itself, but doing it through partnerships. And as I thought this, and I was reading your book, I thought, well, so Professor Hamburger has uncovered yet another, is bringing to our attention in a dramatic way this new mode of power. How does one go about? I'm just sort of thinking practically here, because you say these are sort of, one is, Medicare. That's obvious, but constraints on Medicare. But you say these are a lot of just almost private deals like this, because I read it and I thought, well, this is just another mode of administrative power.
No, it's done by the same people. It's usually done by the agencies. But the agencies don't just have administrative power, which is the power to make rules or edicts or interpretations that function as rules. They also can dangle some money in front of you, or a privilege like licensing, and then say, but we're only giving this to you after you've done something X, Y, or Z, seeking so-called assurances about what you've done. And that's a mode of control that's quite profound. If they can do almost anything that way. And it doesn't always come. So an agency may pass a regulation containing conditions. So HHS has regulations stipulating the conditions on which universities get research funding and requires establishment of institutional review boards and the like. But much of the conditioning that's regulatory comes in site visits, private conversations, or just letters. So it's not, the failure is this: because these are private deals, essentially, all sorts of bad things happen. For one thing, you don't know to whom it applies, because only those who consent are subject to it. So in really rare cases do we know who has submitted to the conditions. You don't know who has or hasn't. What's more, additional conditions are added in informal ways, and when there's no way of knowing what these are, even within one's own institution, because these things are often kept private even within the affected institutions. And this happens to banks and universities. And if it happens to banks and universities, which have so much power, what's the fate of the individual?
As I was also thinking about your book, you think about the administrative state, and it has sort of official legal channels by which it's supposed to operate in terms of proposing a rule, debating it, implementing it. But then increasingly we know it operates outside of those rules and does a lot of unofficial things. like, say, a Dear Colleague letter to every university in America. If you want federal funding, you will basically wipe away protections for those accused of sexual assault, long-standing protections. Is that unofficial? Do you see that as is that conditioning as well?
That's right. And so Title IX has a sex discrimination condition on federal funds to educational institutions. But of course, what's happened is that gets interpreted in semi-formal and then less formal ways. And of course, ultimately, it may depend on private conversations. And just to give you an example, Congress hands off regulatory power to the Securities and Exchange Commission. The Securities and Exchange Commission hands off power to private regulatory, groups, FINRA and the like, right, or the exchanges, and they in turn regulate their members. But they regulate their members in ways that are overseen by the SEC. So you've essentially privatized regulation under the oversight of the federal government. Now, this is highly advantageous, of course, for the federal government. For one thing, they say, we're not forcing you to do anything. It's just a private matter, right? So they can escape any accountability. Again, much of it often turns out to be private and conversation. And then, of course, when rights are violated and there has to be an adjudication, they say, well, there's no violation of rights. It was just a private organization, so no state action. And what's more, when there's an adjudication, not only do you not get a jury, you don't even get an administrative hearing, because these are private institutions. They can handle it as they wish. So there's a complete degradation of our regular system of government through statutes and court proceedings to just private little inquisitorial tribunals. And Title IX tribunals are a good example of this.
Thinking about, you said individual rights. In your research, what kept troubling you about this mode of governance and individuals? I got into this. The book actually begins with an explanation of how it happened. And after dinner conversation, I was having a very nice dinner with wonderful friends. And after dinner, I offered the foolish question, why haven't you published an article that you were circulating in draft? And indeed, it circulated like Zamzadat only in manuscript, quite widely read, but not published. Yeah.
He said, I can't publish it. The IRB won't let me. I thought, what? That sounds like the 17th century, the Inquisition of the Star Chamber. He said, no, it's real. I can't publish it. I could publish it, but they'd never allow me to publish again if I did. And then his wife, a cited geneticist and one of the best in the country, said, yes, I lose several children each year this way because under HIPAA, I can't consult the tissue banks. Now, whatever you think about the use of that information, it's quite sobering that someone in a scientific endeavor cannot consult information in these circumstances. So what was going on here? And I learned it was IRBs. I'd never heard of them before.
Yeah, talk about those.
Well, I never knew what an IRB was. I thought it was bizarre. And for 3 years, I refused to do anything about it, though I was upset because, of course, I didn't want to do administrative law. I didn't want to do conditions.
Yeah.
That's boring.
Yeah.
But it turned out to be ever more interesting. And the final straw was when a friend of mine went to talk to the local ACLU, and they said, oh, yeah, we know all about this. Indeed, they knew the law beautifully, but they said they weren't really against it. They weren't against the censorship. And what institutional review board, should I talk about that for a little bit?
Please do.
Okay, so most people have never heard of these things. They're the ones that introduced the sensitivity about speech into campuses ages ago. If I want to do research and want federal funding, I can't get the money directly. Instead, under HHS guidelines, I have to get the money through the institution, and that's because institutions are more easily controlled. And the institution then gets the money only if it has made an assurance to the federal government that it has established sort of ethical review of research through institutional review boards. Now, that sounds all very jolly, but that can't be bad. But what these institutional review boards are mostly concerned with is speech. They're worried about insensitive speech or harmful speech to the people who study. For example, if you're interviewing somebody. If I were to interview a member of the KKK, I don't really care that much about the harm to the individual, but the IRB will. And I can't ask questions that might cause not only legal and financial loss to the individual, but also might cause stress. Mm-hmm. And so then also one can't publish details that the IRB worries might be harmful to individuals. The net result, of course, is a complete deadening of research, and it's worst in medicine. So in medicine, when there's actually a death toll to this, because when you discourage research, and by the way, you particularly discourage research on minorities, which is one of the goals of IRBs, the net result is, of course, you don't have information to save lives. Now, I'll give you one example just to make this real. Dr. Provost at Johns Hopkins, I think it was 2006, did a study, Michigan intensive care units, of catheters inserted into the heart. These procedures are necessary to save the life of the patient, but there used to be something like a 2/3 death rate because of infection. So what Provost did is he went to these intensive care units in Michigan and said, let's ask the doctors before they do it to wash their hands. And lo and behold, when they washed their hands, they saved, I think, 1,500 lives just in the course of the study. And then it was shut down by HHS because it did not have sufficient approval from the Institutional Review Board. Nonetheless, by miracle, it gets published. And the publication of this, because of information about keeping clean, how important it is in these operations, has saved 17,000 lives a year in the United States alone. Now, what this tells you is that the suppression of information in the institutional review boards, even if it only suppresses a few important studies a year, quickly adds up to hundreds of thousands, if not millions, of lives lost. That's sobering.
Yeah. No, it is.
But this is the blessing of conditions. You can suppress speech without accountability.
In your research, where have the federal courts been on conditions? I mean, from your book, I take it they've largely stood down.
Yeah.
How should they step back up?
Well, so the book, although it's at a broad level about the problem and it's a near political theory, much of it is also technically about law, and actually ends with a checklist for lawyers and judges. There are things that judges can do, and I think the first step is just to recognize the problem. Once one recognizes the seriousness of the problem, I think there will be a response. The other thing that's important to do here is to recognize that actually there isn't much precedent barring the development of doctrine or recognizing what the Constitution has to say. There are precedents, occasional precedents protecting freedom of speech, for example, but they're fairly mild. The precedents have very little to say, actually, about, for example, regulatory conditions. The courts just haven't recognized the problem. So I think one can go to the courts and ask them to work on this difficulty without even having to undo precedent. Now, it's not entirely true. There are areas where they will have to reconsider precedents, but much of it is just unexplored territory. It's terra incognita, which is sad. Isn't it strange? We have a method of government that's now been in place for at least 70 years, perhaps a little more, but it's been widespread since the 1960s. Yeah. And we don't see it.
That's what I was going to ask you is, so when did this really kick into high gear?
Right. Probably the 60s and 70s.
Society.
Yes, but also in the 90s and since then, where the amount of money spent on the states just becomes massive.
Yeah, you note that in the beginning that from most states, it's about 30% of their budget comes from the federal government. And what I've read previously is state bureaucracies have grown, state employees have grown. Federal government employees really haven't. I've read, which kind of speaks to this phenomenon, I think, of indirect government.
Part of it also is that the federal, we think of conditions to the states as violating rights. They also regulate state policy in violation of so-called commandeering doctrine. But they don't just regulate state policy. They actually reshape state governance, which I don't think anyone's really paid attention to other than Martha Durthick in the 1970s. She noted it briefly. Grants to the states have been used to convert elected power to administrative power, because the federal agencies like to deal with state agencies. They don't want to deal with state elected officials. And so they give money on the condition, for example, that the power once exercised by selectmen in Massachusetts towns gets handed over to administrators. And this is a class issue, of course, because it means taking power out of folks in a community who may not have college degrees and giving them to people in Boston, giving the power to people in Boston who are distant from the communities, but have PhDs.
Yeah. Oh, yeah. And government administration or something.
Not a real PhD.
Thinking about this, also, you hint too that maybe the new left was onto something. and the protection of privileges in the late 60s, which I thought that was an interesting argument and made sense in light of the book. Yeah.
I don't want to praise the New Left generally.
Yeah, sure.
But Charles Reich was brilliant and wrote a piece called The New Property, right? And he discusses this problem very accurately and candidly. And he's worried about this, about it, but he phrases it in terms of property, not power. So if he were here in a conversation with us, is I would simply beg him to say it's not really new property, it's a new power. He recognizes that the government is buying its way into regulation and buying its way to adjudication without any process. And he worries about this. But because he's so focused on the new property, the property that consists of government benefits alike, he didn't address the question of power. But he sure was onto it. And I must say, if there's any prior scholarship that I thought was illuminating, it was his. It was more on point than I think anything else I've read.
Well, that's interesting because I've always seen it as sort of the turning in progressive government in America, or the attempt to legitimate it more and more. So I've always sort of recoiled from it. So I thought that was an interesting part in your book. Yeah.
Right. So I would not agree with him about the analysis of the new property. I think actually that did a lot of damage to, for example, rights of due process rights. I think that endeavor to get process for denials of, let's say, welfare ended up degrading, diminishing due process across the board, including constraints, illustrated, for example, by Hamzy versus Rumsfeld, where we now can imprison people without anything more than a neutral adjudicator deciding it, no jury, no judge, etc. And that's a product of, this is a new property, as it will, and the attachment of due process to that. But at the same time, I want to give him credit where it's due. He did understand that there were risks in the purchasing of compliance.
More sticky question. I take it you don't think all conditions are unconstitutional.
Right.
So how, in thinking about the government extending conditions on privileges or attaching them to privileges, how do you sort of work out an analysis? Like, it's something like plea bargaining. What do you think about that?
Right. So most government conditions, such as we'll give you money for an airplane on the condition it flies, are perfectly reasonable and lawful. And the book goes out of its way to emphasize this is not a complaint about conditions on the whole. I do teach contracts law, and I know the value of conditions. But on the margins, there are conditions that are being used for less innocent purposes and to regulate, to deprive people of rights, to control the states, and so forth. And that's what's very dangerous. So, for example, Cass Sunstein has discussed nudges. I can't say that I think most people like being nudged. Feels more like a push usually, but that's not necessarily unconstitutional. What becomes problematic is when the conditions deprive one of rights, or it's used as a mode of regulation. And plea bargains. Let's talk about that. Is 95, 97% of criminal cases end in plea bargains, at least at the federal level. It's prodigious. And many of those conditions are not unreasonable, but they can overstep the line. And it's an interesting, delicate question. So, for example, suppose you're asked to give up your right to a jury trial. Well, that's not necessarily unconstitutional. The jury trial is not mandatory. You can agree to give it up voluntarily or when you're given something. But what if you're asked to give up your jury trial in future cases? Well, that would be different. That's an attempt to restrict your exercise of the right in the future. More commonly, the more typical sort of condition would be to require one to provide testimony or not exercise one's right of against self-incrimination. If that extends too far into the future, then I think one runs into constitutional problems. But if it's confined to the case itself, there needn't be a problem. So one has to parse these things in a fairly careful way to get there. What I found most interesting.
Are you saying, and I'm ignorant here, are you saying federal prosecutors are frequently...
I'm talking about federal prosecutors.
Federal prosecutors are frequently reaching beyond the case at hand to future cases with defendants?
No, I don't know how frequently it happens. It just happens occasionally. But it sometimes does happen. And then one has to be careful. when we get to the free speech conditions, I think there's something important to be observed in the word abridge. The First Amendment is actually carefully worded. Congress should make no law abridging the freedom of speech or of the press. And that word abridging actually is helpful because, when Congress passes a statute that restricts what you can say, one might have a difficult question as to whether or not the law abridges the freedom of speech. But when it or an agency gives you money on the condition that you similarly restrict your speech, it's actually much easier, because if the condition goes further than what is constitutionally allowed in a direct restraint, you know that it's abridging the freedom of speech, because the word abridging suggests that you're going a little bit further. And so we actually have some clarity in the speech cases that isn't always true in some of the other rights.
So, for example, you receive, you don't have to pay taxes, you're a nonprofit, but with that comes all sorts of restrictions on your speech.
Right, and so the limitations on nonprofits not to get involved in political speech and elections or in lobbying, as you know, I've written on this, and it's first proposed by Hiram Evans, the rather unlovely imperial wizard of the Ku Klux Klan, and it's a way of silencing relatively orthodox, i.e. Catholic institutions, even if it's the risk of silencing others. This is a constraint on speech and on political speech. You would have thought we'd all be concerned about that. But we're told sort of reassuringly that no, it's just a condition on a privilege, that of tax exemption. But it's really just saying you're going to get different tax rate depending on whether you silence yourself. And once you understand it that way, it's quite clear this is actually a penalty on speech. But even if you just understand it as a condition, and by the way, I say that because lowered taxes and receiving money are actually quite different. You have a choice as to whether or not you're going to receive money, not as to whether or not you're in the tax system. But even if you just view this as a condition on a privilege and there's no sort of coercion here, this is a condition that one could never impose directly, right? Mm-hmm. The only reason it's been accepted is because it's thrown in as a condition on a privilege. And that shows how these are used to evade the First Amendment.
And I take it, there is, at the level of political theory, there's this sort of assumption here working that rights themselves, property, is something that the government really has control of and doles out. And thus, so I'm not violating, like to the nonprofit, it's like, well, you're getting this tax deference. Aren't we generous to you? And it's like, well, why did you assume that was yours to begin with? That's kind of the way I've always looked at it.
Right. So this gets back to the debate between Pufendorf and Locke. Pufendorf understood that contract preceded government, but he thought that property was the product of agreement. And so from that perspective, it wasn't clear that property necessarily preceded government. It could have followed the establishment of government, in which case property is dependent on government largesse, and there's a certain priority of government before property, and property isn't really protected. John Locke, so he's often thought to be responding to Hobbes, is also responding to Pufendorf quietly. And John Locke offers a different account of the development of property. It's the so-called labor theory of property. Put your labor into something that becomes yours. Why would he do this? It looks, if you take this as a grand theory of property, it doesn't explain all property, and therefore seemed rather weak. But he wasn't trying to explain all property. He was just trying to show that some property, the institution of property, pre-exists government. And that's crucial because property is this metaphor, if you will, for all liberty. It's something that's yours, and that precedes government. And so that conversation between Pufendorf and Locke, although I think often missed and or misunderstood these days, is very relevant here. In our traditional vision, property precedes government. And by the way, notice, if the IRS could treat any sort of tax exemption as largesse, to which you can attach conditions depriving you of your rights, notice it can just give you 100% taxation. And then when it lets you keep 1%, it says, but of course, on the condition that you could subvert all rights instantly this way. So I don't think it makes sense.
So the progressive mode of government has to dispense then with I think that with a lock-in position necessarily if it's going to be able to move money around and engage in the transfer payments and the regulatory system that it needs to. So it sort of has to disestablish that mode of thinking. You find in the book, I think, that Americans have largely accepted this, but maybe they need to be reminded of what they've forgotten. Yes.
Well, I think what's happened is that money has appealed to people, as always, and the folks who get money don't worry too much about the conditions. But as they pile up, there are profound costs, not only to the individuals and institutions, but also to the whole nature of our society. We're turning into a society in which everything can be bought. And I think actually a lot of progressives understand that this is dangerous. A lot of progressives regret commodification, as they would put it, right? And what we've done is commodified our government. And there's something which I would have thought people from many different perspectives can agree on, that this is somewhat worrisome. Can I add a thought about how dangerous this is?
Sure.
To the degree conditions are the primary means of privatizing control, privatizing regulation by funneling it through employers, universities, banks, and so forth, there's a very great danger that all institutions will end up being aligned under centralized control. I discuss this towards the end of the book. The danger is that if federal money and with it federal policy runs through the states, runs through the banks, runs through the universities, runs even through churches who try to silence their members to avoid violating 501c3, we end up in the system in which all the institutions are aligned and the opportunity for freedom is radically shrunk. It used to be, because institutions were not aligned in this way, either because institutions were different and because regions were different, you could find some sort of solace, some safety, if not at one level of the system, then in another, if not in one type of institution, another. If you don't fit into the banks, you can fit into the universities. If you don't fit in there, you can fit in let's say, in state government. That's no longer true, because they're all being aligned in their policies, mostly through conditions, also to some degree through direct regulation. Well, and that ultimately is very, very dangerous.
I mean, just to go back to the Dear Colleague letter to higher education, I mean, did any institution receiving federal funds object to that?
I don't know, but there certainly wasn't mass rejection of it.
Yeah.
and notice, it's one administrator to another. They're talking to their own people.
Yeah. And realizing that their institution would fall apart without federal funds.
That's right. But they also they fail to realize that their institutions are going to be rendered impotent and unfree and soon utterly irrelevant if they accept the conditions.
I can think of, since that letter was issued, a number of private higher education institutions coming into being, which made it very clear they would never take federal funds. But those are a few.
Very, very few.
A scattered few.
Right. Right. Hillsdale doesn't take federal funds, but Hillsdale's a lonely voice.
And I think a lot of these new class schools that are coming online, they're very clear, even in states like where I'm at in Indiana that have very widespread voucher programs. They will take none of that money because they're worried about conditions that come with it. Is this just, though, the way of, I mean, I'm thinking about it. I mean, there is just sort of you're offering people something, they're going to take it.
Yes, but they're corrupting us with their own money.
Yeah.
They're bankrupting us by dangling in front of us things we can't afford with conditions that will destroy our freedom.
So as you think about this, what are the low-hanging fruit that could be picked here to try and peel away this mode of governance?
So I think it's already happening. The states increasingly are being offered money on the condition they submit to conditions dictating their policies. Certainly in connection with vaccines and the like, this is happening, right? Mm-hmm. Or the tax reduction earlier this year, the states were told you can have federal money, but you're not allowed to reduce your taxes.
Yes.
So this is problematic on many grounds. For one thing, it's a mode of regulation through conditions, which shouldn't be allowed. For another, it's the spending to the states is unlawful. But at the very least, there's a commandeering doctrine, which really just reflects the structure of our Constitution. Now, the judges will say commandeering, that's about the relationship between two separate sovereigns. Not really. They get that wrong. It's really about our right of localized self-government. It's about freedom, not just structure. And the structure depends upon that freedom of localized self-government. So it's really much more threatening than they think. And although the term commandeering suggests that there has to be coercion or gun to the head, as the Supreme Court's apt to say, that's actually the standard for duress in contract law, actually 19th century contract law, not even contemporary contract law. And structural problems, which is what this is, do not need any coercion. You can corrupt the structure of the Constitution with money as well as by force. So I think we're going to see arguments along these lines, arguments, I think drawn from the book, that in fact the commandeering doctrine is grossly misunderstood by the court, and that these demands on the states not to lower the taxes or to impose vaccines and the like are unconstitutional interferences with separate sovereignties and with our right of localized self-government. So that's, I think, could be an opening wedge.
Also, something as I'm listening to you and I'm thinking, particularly with regard to the states, is sort of the increased ideological competition over policies and, which policies lead to growth and flourishing, economic flourishing in particular. And it seems to me you're also getting this realization amongst both sets of governing elites of how they want to live. And, red states are making decisions based on that as to what money they'll take from the federal government. Witness red states like Florida not taking money regarding unemployment benefits because they think it actually would lead to a decreased labor market, depressed labor market. So already it's almost like politics, the return of politics could also help here.
Possibly. Anything that helps, I think, would be welcome. My fear always is that we'll be woken not by ideas, not by ideology, but by calamity. And it's a stiff competition. Will it be in foreign matters or domestic matters that our collapse will get our attention? And will it then be too late? I don't know.
Philip, maybe we'll end on that note.
Thank you for giving me an optimistic ending.
As we think about Philip Hamburger, author of the new book, Purchasing Submission. I hope it has the impact all of your other books have had. Thank you for discussing it with us today.
You're very kind. Good talking with you. Thank you so much.
This is Richard Reinsch. You've been listening to another episode of Liberty Law Talk, available at lawliberty.org.